Muy bien, pues continuamos con la última ponencia del día de hoy. Como les comentaba, vamos a entrar un poquito en el área de cómo es que las personas que viven con algún TEAF habitan el sistema de justicia, ¿no? El ejemplo de Canadá. Y para esto tenemos el honor de contar con la presencia de Morgan Lawrence. Ella es abogada especializada en defensa penal con experiencia ante la Corte Provincial, el Tribunal del Rey y el Tribunal de Apelaciones de Manitoba, así como en diversos foros administrativos. Es licenciada en Justicia Humana por la Universidad de Regina y estudió Derecho en la Internacional en la Universidad de Leiden, antes de graduarse en Derecho en la Universidad de Manitoba, donde continúa ejerciendo como mentora y ponente invitada. En 2024 fue nombrada miembro de la Junta de Apelaciones de Salud de Manitoba. Su trabajo va más allá de la defensa legal e incluye un firme compromiso con la justicia social, participando activamente en organizaciones comunitarias. Parte de su trabajo se ha centrado en el análisis y el enfoque informado sobre los trastornos del espectro alcohólico fetal dentro del sistema de justicia penal canadiense, contribuyendo a concientizar sobre cómo estas afectaciones eh, impactan en la vida y en el comportamiento, pero también en la responsabilidad legal. Bienvenida, Morgan. La palabra es tuya.
Good afternoon. First, I must say, this is a very different arena than what I'm used to. I can tell you that I tend to present evidence in court, sometimes on a daily basis, in my effort to assist folks who may be impacted by some form of cognitive limitation, but specifically for today's lecture, speaking to FASD exposure. So first I want to say thank you. Thank you to everyone. Thank you to all the participants today and yesterday, and what brings us here to talk about a shared topic. What's very interesting to me is I met some of the participants that you've come to meet over the last 2 days at a conference this year in Seattle, which I was very privileged to participate in. I was an attendee there just simply trying to learn more to better represent folks that I have the privilege of representing in court proceedings. And now here I am. I'm happy to share with you my experience as a criminal defense lawyer. I also want to say I'm a lawyer. I'm legally trained. It has been very nice for me to be in the company of some incredible academics over the last 2 days. There are many other lawyers doing exceptional work in this area. I'm here to share with you my exposure and my experience on this topic. And I'm going to learn. There we are. It's been a long time since I was in school making presentations, so we're going to do our best. I thought before I went too far, I would talk to you a little bit about where I'm from. Of course, having some background or exposure to some of the numbers and representative, well, why the court exposure is what it is, and how I can share my best practices with you. So I'm from Winnipeg, Manitoba, and now I can see from the slide that it actually didn't keep the last little star of the city. I don't know. I want to break this. Oh, yeah. There we are. In any event, there's a center province there, where you can see kind of 4 larger lakes. I'm gonna walk. You can see that the province is very well exposed with kind of different environmental opportunities. The city of Winnipeg makes up 54% of the population of our entire province. That's an important piece that I want you to hold on to as I'm going to expose to you some information related to the FASD Justice Program, which was spoken to on the previous presentation. The city of Winnipeg, again, making up that just over 50% population, holds household income per capita noted at $47K, and that's Canadian dollars. I did a quick translation, and that would be 34 US dollars. I would say the representative nature of that household income would say that, generally speaking, that is a, oh, very well. Okay, thank you. I would say that that's generally a medium to low income threshold for what we are talking about with the residents in Winnipeg, Manitoba. So I'll begin first talking about the FASD Justice Program, something you might be a little bit aware of. Most importantly, I am not necessarily a stakeholder in this program. I am not an inventor of the program or consulted on the program itself. By the time I became a lawyer, I'm very happy to say that the program very much was already initiated. So the FASD Justice Program, or FASD-JP, is a program that assists people who carry with them a diagnosis. That second point there is one of the most important points that I wish to highlight for us, is it has a limitation of assisting people only within the city of Winnipeg and only within the age ranges of 12 and 25. The Justice Program is exceptional, I have to say. They have an ability to provide multidisciplinary assessments and supports, as it states there, but also the effort of the program is to provide a client-centered or individual-centered approach. It assesses folks with housing, with social supports, with financial supports, everything you can imagine. For me as a criminal defense lawyer, if I'm able to get a client into the FASD Justice Program, I really do feel with great confidence that they are supported for the next few steps along their journey. What else comes with the FASD Justice Program that's important to note is there should be, or there's some understanding that the justice participants inside that courtroom come with some FASD teachings, meaning what we would expect as counsel is that we are going before judges or representatives of the judiciary who come into that courtroom with some exposure and education. The FASD courtroom itself can be adapted in certain ways to be more suitable for the applicant. And as mentioned, I think in the earlier presentation, you're supporting that individual with a number of different sources outside of the criminal justice system. They tend to be supported by social services, social workers, housing workers, cultural workers as well. It can, in many cases, result in reduced sentences. But what we should carry is the goal isn't necessarily a reduced sentence for an individual who may or may not be carrying a specific diagnosis. The goal of the FASD Justice Program, again, from my understanding and perspective of the program, is more of a nuanced perspective, an ability to sentence that individual that is appropriately proportional to their moral blameworthiness, what they carry with them and what they understand. It's important to note, however, that there are limitations to this program, and I'm going to get into that in a moment, but one of them being that this is an application-based program. I have a note on my slide here, and I want to make sure I'd be remiss if I didn't take a moment to address this. Again, as counsel, having the privilege of working with many people who carry different cognitive diagnoses, what's surprising to me is most, if not all, I would say all, nearly, there are a few exceptions, reach me, find themselves incarcerated, whether it be for a serious offense or less serious offenses, and they have not yet been assessed. They have not yet found social supports. So what I experience are individuals with limitations in their experience in life kind of falling through a number of social functions. And after they fall through those different social functions, they may find themselves incarcerated. And when they're incarcerated, you meet your lawyer, and your lawyer tries to understand what's going on. Now there's a lot of words on that slide. I wanted to include this because on the left-hand side there, it's a screenshot of CBC News. This is our national news broadcasting network. What it tells us is the FASD Justice Court, just a court, not necessarily the program, but the court which educates judges specifically and provides different assessment tools in the sentencing, began March 2020. This article explores that since the program's start, admissions to the program or applications to the program tripled. So the awareness and the need absolutely exploded. I want to take us to the third point on this slide. Yes. Research on FASD prevalence in Manitoba found that the rate in Stony Mountain Institution is 10 times higher than the general population. I want to step that back a little bit. In Canada, we have generally two types where folks can be incarcerated. There are provincial institutions and there are federal institutions. A provincial institution, there are a number of Manitoba, and an individual who is housed at a provincial institution is either A, not yet sentenced, they are on remand time, or B, sentenced to a sentence less than 2 years. They will not serve even 1 day over a 2-year sentence. If they remain sentenced for less than 2 years, they remain in the jurisdiction of the province. I would expect much of that becomes a funding issue. So the province of Manitoba takes care of that individual. People who are housed in provincial institutions, I would say, in my experience a lot more of kind of that coming and going. Individuals who are arrested and released and arrested and released, not yet sentenced. From my experience, provincial institutions would likely have less stability than that of a federal institution. Now, Stony Mountain is our federal institution in the province of Manitoba. Federal institution being funded by the Government of Canada. The individuals who are housed at Stony Mountain are currently serving a sentence over two years. We would say often in court, 2 years plus a day. Stony Mountain should statistically represent the individuals with more serious offenses, serving sentences for more serious, sometimes violent crime. So if we go back to this third bullet point, Stony Mountain Institution, our federal institution in Manitoba, recognizes that their inmate population has a 10 times higher diagnosis of FASD than the general population. I think there are a number of considerations that come into play when we consider that fact. However, again, taking a step back from that, federally incarcerated folks come into that system and our federal incarceration setting has funding. So after someone is sentenced, let's say to a 2, 3, 4-year sentence for whatever type of crime may have led them there, they are housed, they are stable, they are locatable, and they are funded to receive assessments. So I think something has to be said for that. Move on here, our last few points just taken from this article, and of course this article being something that's publicly available. If you have any questions, I'm happy to assist you. It takes us back just to remind us kind of what the goals are for FASD court. That being that offenders with a FASD diagnosis enter a guilty plea and are brought before judges who consider the diagnosis, how their diagnosis may have contributed to their presentation or to the crime itself. So what's also important there is in the Canadian criminal justice experience, from my experience so far, we only have an ability to assist folks with a cognitive limitation of this nature after conviction. Our goal in this court setting is to appropriately sentence them. That's after the conclusion perhaps of a trial, or that's where the individual takes responsibility for a certain act. I think there is still a lot more work to come to properly represent the individual before a conviction or a guilty plea takes place. What I'm able to share with you today, however, there are kind of two venues in Canada, Manitoba specifically, how we assist people with a FASD diagnosis, one being FASD justice or FASD court, that being a young individual who has applied, who is able to, take me to my next slide, an individual who has applied, who has been accepted to the FASD justice program, and who is able to participate in the FASD justice program. We have other means to assist people with FASD in the criminal justice context, that being, how do we help them appropriately be sentenced after a conviction is endorsed by the court? I apologize, this is a very quick law lecture for everyone here. So we've talked a little bit about the FASD justice program, and I do have some limitations to that program that I'll get to in a moment. But I want to talk now, what happens to the individuals who are too old or perhaps present with a type of criminal act that the FASD justice program would not accept? What happens if the individual is not able to comply or does not present with the personal circumstances where they're able to comply with the program? How can we help that individual in the criminal justice context? And that's where I'm going to talk to you a little bit about the sentencing approaches in the criminal justice system. I'm sorry, this is where it gets a little bit legal. Canadian Criminal Code has a section 718, 719 that stipulates to every actor in a court proceeding how we are to advocate, how I am to advocate for an individual to ensure that they are properly sentenced. These are the same principles that a judge is going to access when they turn and sentence my individual that I'm representing. So 719 is something that I've reflected on my slide here, is that a judge, when sentencing an individual, must sentence the individual due to the gravity of offense, so the severity of the criminal act, and I've highlighted, and the degree of responsibility of the offender. So the violent act or act, and what we say in law, the moral blameworthiness of the individual. How did that person carry themselves into that criminal act? What I'm going to get to here is the highest court of Manitoba has made clear that there's now a legal analysis, there's a legal test to establish that evidence in court. So for me, when I'm presenting or I'm advocating for a person who is impacted by FASD or some type of cognitive limitation, I need to demonstrate on a three-pronged test to that court how that limitation oppresses upon that accused person. And if I'm not able to meet this test, I'm not able to find different sentencing options for the individual in that court setting. And I say this to you because I think this is a unique opportunity where I can appreciate that I'm here today legally trained. I'm a criminal defense lawyer, but I share the company of so many academics and people working and living in this environment. And I want to impress upon you that if you're assisting an individual in a forensic sense, in an academic or an assessment sense, as counsel, this is what I need to see out of their diagnoses or forensic documentation to be able to best utilize it in court. So a case called Okamau comes from our Court of Appeal in Manitoba, and it presents this specific test. And this is the test as documented in law, but I'll provide to you a bit of a summary. What it says is, one, is there clear evidence? Is there evidence that is objective, that the state, the Crown Prosecutor in Canada is conceding where an individual is in fact impacted by some type of mental illness or other cognitive limitation? That's step one. As counsel, step one generally indicates that, am I able to get an assessment from my clients? If so, generally speaking, at least in my experience so far, it's very rare that the state would object with medical documentation. So step one is fairly easy to meet so long as you have funding. And that goes to limitations that I get to next. Step 2 is one of the most difficult pieces. And I share this with you because it may be something that we can explore at a later date or a further conversation for another day. But as counsel, I have a medical assessment. I file that medical assessment. It's evidence at a sentencing hearing for an individual. I must then, with that evidence of the individual's limitations, be able to impress upon the court that there is a nexus, that there is a clear connection between the individual's diagnosis and this specific criminal act. So what I need forensic professionals to be able to say for me to pass step 2 of this test is that this individual specifically exhibits a symptom of impulsivity, let's say, and that impulsivity can translate to an act such as A, B, or C. It can be very difficult to find evidence to produce in a criminal context to satisfy this threshold, which unfortunately leads a number of people who, again, if we take a step back, who are over 26 years of age, who are not able to participate in the FASD justice program. And as counsel, we're doing our best to say to the judge that this individual has a compromised IQ, has a compromised cognitive ability or cognitive standing. But if I'm not able to produce evidence to say, not only is this person experiencing a limitation of sorts, but that limitation has tied specifically to this criminal act, I'm going to have difficulty in a criminal context in assisting this individual, in my opinion, in providing a fair sentence. They otherwise would be sentenced as any other individual who's committed a similar act. Limitations. I've talked about them throughout the course of my presentation so far. I thought it was important to include limitations that I'm experiencing in counsel in Canada. Of course, the FASD Justice Program and the FASD Court is, from my understanding, the only one in Canada. So there's a lot to celebrate. It's exceptional. The Manitoba Court of Appeal in Okemau provides a legal test saying there is direction from the court to do this. I'm sharing that limitations are still apparent because we are here today and yesterday to think about systems to create going forward. So despite, coming to this conference with a great deal to celebrate in Manitoba, I do want you to be aware that I think some organization to the limitations is important to note. So for the FASD Justice Program, it's application-based. I mean, if we slow down and think about that, how might an accused person have to present to be able to suitably apply to a program? What type of access to supports will they need to have? Simply being able to access an application, ability to read and write, to have social networks available to even get that application to them. That can be very difficult. The program is limited by capacity. It's a funding issue, of course, as any other program might be. But not only do we have the limitations of age for people who are under 26, many people who are under 26 still do not qualify because the program is at capacity, which is something to celebrate. But then we talk about how many people who are impacted by FASD who do not have the opportunity to apply to that program. There is an exception to serious offenses that do not qualify as to whether or not a certain individual may or may not be suitable for that type of supervision. And to the middle point, I say an applicant must be willing and able to participate. And I wish to share an experience of my own. I had a young individual. He is diagnosed with FASD. His exposure to the criminal justice system for much of his life was in his kind of youth chapter. He was exposed to the FASD justice program as a youth. In Canada, adulthood is 18, so he turns 18. He then transitions to the adult criminal justice system. Now, as he's 18, he is, I would say, underhoused, but he lives in kind of flop houses or in unsafe environments. He is no longer supported by, again, in Canada, our Child and Family Services Network, which means he doesn't have certain funding available to him. When he became 18, his resources, which were already limited, really deflated. This individual is known to the FASD Justice Program, and the FASD Justice Program, unfortunately, was unable to assist him because he was underhoused. So he's hard to locate, he's hard to assist, and their resource capacity is that they assist folks who present differently than the client that I'm sharing, which is very, very sad story to share. Now, if we talk about FASD itself and personal circumstances and how an individual might be sentenced if they do not qualify for the FASD Justice Program, some of the limitations that I experience as counsel is funding. If I'm assisting an individual who may present with some type of a severe cognitive limitation, they are likely a state-funded accused person. If they are in fact a state-funded person accused of crime, then any access to forensic assessments, to forensic testing, must then be paid for by the state. That's an application process for counsel, and the state has the right to say yes or no, or what forensic professionals they may fund, and some forensic professionals are more expensive than others. Now, if the state is to fund you and you get an assessment, you are likely to get a summary-based assessment, which is 3 to 5 pages that I provide to the court that kind of touches upon a deeper issue for the individual. They're not able to provide a fulsome assessment due to funding limitations. Now, beyond that, if I'm representing an individual, and we go back to that 3-pronged test where I say the number one piece Crowns or the state prosecutors tend to agree with, if our prosecutor or state representative did not agree with, well, that presents another funding issue, because that means I then need my expert to be in court and to testify, and their time and preparation must also be funded, which is another limitation that state-funded individuals experience. This last piece, of course, here being we must be able to demonstrate a clear nexus between a person's cognitive limitations and why they are before the court in that specific arena. These are my conclusion comments to share with everyone. In either system, I think it's very important to note that our goals are to better understand an offender, to appropriately address their involvement in the criminal justice system, which is aligned to their moral blameworthiness, what brought them into that criminal act itself. The goal, of course, is for better outcomes for the individual, and I would say an individually centered approach to sentencing. This third piece being, in the Canadian context, generally speaking, for most criminal acts, a judge is going to consider sentencing principles such as denunciation and deterrence. How am I going to denounce you or the community from committing such an act? And how am I going to deter you, from that same act? So we must ask ourselves, how can we properly denounce and deter an individual with a certain type of cognitive impression? I think this is the end. Yeah, that's it. Questions?
Muchas gracias, Morgan, por tu participación. Me paso a este lado. Pues tenemos unos cuantos minutillos. Si alguien tuviera un comentario, alguna pregunta que hacer. Por allá. Muchas gracias. Ahorita te dan un micrófono.
Hola, muchas gracias. Estuvo muy interesante toda la información. Me surge la pregunta, ¿cuál es el delito con el que más se encuentran ustedes? ¿Cuál es el delito con el que más trabajan? Y si ese delito tiene relación con este padecimiento.
That's a very interesting question. Sorry, I have to go back and forth here. My experience as a criminal defense lawyer Well, I mean, what's interesting for me is what's aligned with this conference and my personal practice is that I have the privilege to assist an individual just next week. I have been his lawyer. Oh goodness, I think he was arrested in 2022. So we've been working with him for some time. And he's finally going before court next week, Tuesday, to be sentenced. And I can tell you that he's being sentenced for a serious violent event. So I wouldn't say that there are certain types of criminal acts where there's an exception to every rule. I've represented an individual who has an allegation of a homicide, and he carried a diagnosis. I also represent a lot of people who have more kind of daily exposure with the criminal justice system, unable to follow administrative conditions like reporting conditions or probation, or some more kind of petty acts like theft. But I would say in my experience, the exposure is kind of across the board.
Muchas gracias. ¿Alguien más? Jennifer.
I loved your presentation and I love the program. I did want to point out, though, that there is research out there that indicates that people with FASD are actually more likely to be a victim of crime than perpetrating a crime. So think about that. You know, if you are impaired in your judgment and maybe don't read social situations correctly, it's very easy for people to take advantage of you. So I'm not saying that people with FASD don't commit crimes, because they do. Absolutely. And the rates of FASD in incarceration are very high. But I would say also look at them as victims of crime just as much as you're looking at them as perpetrators of crime.
Thank you. Tenemos otra pregunta por allá. Gracias.
Thank you, Morgan, for the presentation. And I'm just curious if there's a reason for the age limit.
I wish I knew that answer. I'm in that arena simply as a lawyer. I would expect at that age, you mean for the FASD justice
Yes.
program, the
Like for the
26?
12, yeah.
I would expect that that age is simply a reflection of a resource limitation. However, that's my assumption. I can reach out to some of the actors of that program and provide that answer for you if that's helpful.
Muchas gracias. ¿Hay alguna pregunta o comentario más? Si no, nada más te damos un reconocimiento por tu gran participación, Morgan. Muchas gracias por estar con nosotros.